Semua ahli media kerana hadir persidangan ini. Saya telah filekan satu usul di mana saya memohon supaya Tuan Speaker mengkaji semula keputusan yang beliau buat pada 17 hari bulan 10 tahun ini, iaitu hari Isnin, di mana beliau membuat keputusan seperti berikut. Ya, saya baca. Ini daripada Hansard yang saya terima dan ini apa yang disebutkan. Saya mendapati beberapa soalan dalam pertanyaan jawapan lisan dan bertulis serta usul yang telah dikemukakan bagi mesyuarat ketiga penggal keempat Parlimen ke-13 kali ini berkaitan dengan satu isu yang menjadi kegemaran ahli-ahli yang berhormat, iaitu isu tindakan sivil in rem oleh Jabatan Keadilan Amerika atau singkat DOJ. Kemudiannya beliau Tuan Speaker memutuskan seperti berikut. Jadi untuk itu, setelah meneliti isi kandungan pertanyaan-pertanyaan tersebut, saya mendapati bahawa ia adalah perkara yang masih dalam pertimbangan mahkamah ataupun subjudis. Oleh itu, menteri yang berkenaan tidak perlu jawab kepada perkara-perkara tersebut. Ya. Jadi saya kemukakan satu usul di bawah Peraturan Mesyuarat 43. Seperti mana semua di sini sedia maklum bahawa keputusan berkenaan dengan apa-apa perkara yang berhubung kait dengan peraturan mesyuarat boleh dibuat oleh speaker yang bijaksana semasa persidangan, dan ianya adalah muktamad. Dan sekiranya kita nak mencabar keputusan itu, maka prosedurnya adalah untuk kami mengusulkan satu usul di bawah Peraturan 43 supaya satu permohonan dibuat supaya ianya dikaji semula atau dirayu keputusan tersebut. Ya, jadi hari ini saya telah pun memfailkan notis usul ataupun usul tersebut melalui satu surat yang dialamatkan kepada Tuan Speaker Dewan Rakyat Parlimen Malaysia. Dan secara ringkasnya ada dua sebab atas mana kami pohon agar keputusan tersebut dikaji semula. Pertama, menurut apa yang saya dapati dalam kajian, kita dalam parlimen, kita ada parlimen di merata dunia, di mana kita ada buku yang melengkapkan keputusan-keputusan dibuat oleh parlimen di negara lain, the Commonwealth Parliament sebagainya. And of course the main reference point is what is known as Erskine May. Now, saya telah pun kemukakan bahagian yang penting dalam petikan daripada petikan Erskine May, di mana dinyatakan berkenaan dengan ungkapan subjudice. Yeah? And I'll take you now to that part, matter subjudice. Reference is made to the page 365 of the book, di mana cukup jelas dinyatakan bahawa the rule does not apply to matters which are subjudice in courts of law outside, and of course in that country they talk about outside Great Britain and Northern Ireland. So, jadi di sini juga adalah menjadi pandangan kami bahawa this rule does not apply to cases that are being held outside of Malaysia. Itu satu. Nombor dua, sekiranya Tuan Speaker tidak bersetuju dengan saya, of course, then he's going, with rigorous respect to him, he'll be setting a new precedent, because he'll be acting somewhat against or different from the conventional stand taken by all other Commonwealth parliaments. But if he is not with me on this, soalan yang kedua yang berbangkit adalah ini: sebelum kita boleh membuat keputusan sama ada ataupun tidak sesuatu perkara itu subjudis, kita perlu tahu dengan teliti apakah asas kes yang dikatakan berlaku di negara lain itu. So in other words, before you can decide whether a matter is subjudis, you must appraise yourself of the facts and circumstances in the other case. So if there is reference made to the DOJ here, the question which arises is this: has Tuan Speaker actually seen all the documents in that case, which includes the claim, responses thereto, and other documents? And if, of course, the proceedings have started, what has been decided until today? That's a question I asked Tuan Speaker in the Dewan. I don't see an answer to it in the Hansard, and I don't remember hearing one. Perhaps Tuan Speaker can tell us whether or not he has done that. Because if he has not done that, then the question arises as to how it is he can decide that the questions that have been asked relate to the issues in that case, and number two, whether or not by answering those questions there will be prejudice to the parties involved in that case. Thirdly, has Tuan Speaker actually determined who the parties are to that case? Because if you have not determined who the parties are to that case, then the question of subjudice doesn't arise. Tuan Speaker earlier had a press conference, I am told, in which he referred to Standing Order 21. Now, Standing Order 21 relates to questions that are posed to ministers. Now, his argument, as I understand it, and I stand corrected, is that questions must be posed to the right ministers for answers to be given. That's a general proposition. I think all of us accept it. There's no need for him to tell us that. It's there. 21 says it. I think what is important is 23. The 23 speaks about sub judice in respect of cases that are, or questions that are posed to the ministers. And in this regard, I've taken the liberty to produce it. If you look in the middle of my letter, 23(1)(g) says, a question shall not be so drafted as likely to be to prejudice a case under trial, or be asked to any matter which is sub judice. So in other words, the question again, the test is prejudice. And number 2, 36(2), this is what he also referred to. It reads as follows: reference shall not be made to any matter which is sub judice in such a way. So not generally sub judice. The rule says reference shall not be made to any matter which is sub judice in such a way as might, in the opinion of the chair, prejudice the interests of the parties thereto. So we come back again to basics. Number 1, it would appear to me, from my reading of the textbooks applicable, that the rule does not apply to proceedings that are not within jurisdiction. So in other words, it does not apply to proceedings overseas. Number 1. Number 2, if Tan Sri Speaker says otherwise, the question is whether or not he has appraised himself of the facts in that case. I've asked that question, I have received no answer, and I hope that he will give us an answer as soon as possible. Number 3, if you remember correctly, this issue of sub judice came up in the last session as well. And I rose in the day 1, and I think all of us recollect that it was a consensus, and I stand corrected again, that before a ruling can be made as to whether something is sub judice, first, the Member of Parliament who proposes to raise that question must be heard. So in other words, you must give an MP an opportunity to explain or to ask the question, and it's only when objection is taken by the other side on grounds of sub judice, then the chair must decide. And he must decide based on the facts of the case. And it is basically a situation where he has to consider question by question. So he cannot make a broad and blanket ruling, which seems to be the case here, as in respect of the DOJ matter on the 17th, on Monday. Yeah? So I think at the end of the day, Tuan Speaker was right to say that his decision is final under Standing Order 43. But Standing Order 43 says that we can ask, or we can file a motion and ask for his decision to be reviewed, which means that this motion will be put to debate in the day 1. Now, since the Speaker has thought it fit to come out and have a press conference earlier, and I think that's what happened, if I'm not mistaken, where he tries to explain himself, and now I'm having a press conference where I'm explaining myself, I would suggest to the Speaker, with respect, why don't he allow this motion to be brought in the day 1 so I can face him in the day 1 and we can debate this, and let us get a ruling on this, not just taking into account what I have to say and he has to say. Let us also give an opportunity to all other members of Parliament who are interested in this issue to debate, so that we can come up with a clear guide in respect of even future references to what are cases where sub judice applies and sub judice does not. The short of it is this: I am of the respectful view that the Honourable Speaker is wrong to have ruled that any matter relating to the DOJ is disallowed on grounds of sub judice. I stand corrected, as I said. He has his view, I have mine. I think the best way for us to deal with it is for him to allow the debate so that both of us can ventilate our views and of course take into consideration what the other MPs have to say and a decision made. Yeah? So I think that's procedurally what has to happen is we'll file the motion which I've done, and of course it's then up to the Speaker to decide whether or not he will allow a debate. You all remember when Gelang Patah was suspended before, I also filed an application. That application remains an application on the file. Now let us look at this seriously. I think when we have Order 43 or Standing Order 43, if it says that a motion can be filed, I think we should make sure that those motions are actually filed. If it's to be rejected, then written grounds perhaps to explain why. But I think, and I call upon the Right Honourable Speaker to give effect to Standing Order 43, because Standing Order 43 is the only way in which members of Parliament can challenge his decision. We respect the fact that he has a final say as the Chair of the House. But I think we have to give Standing Order 43 effect. Otherwise, you're going to have decisions made and all motions filed, put aside, and at the end of the day, right, to my mind, the provisions of Standing Order 43 become academic, if not nugatory. Yeah? So I don't think that is what you call the intent and purpose behind having Standing Order 43. Right? So that's the short of what I have to say. Unless any questions, Tony, you want to say something? All right, that's a very simplistic way of looking at something without looking at the substance of it. An incident may occur in Malaysia, which would require a response from the Malaysian government in respect of what happened, what went wrong, and what the government proposes to do to correct it. So the incident happens here, but a case may be brought in respect thereof in a different country. Now let me give you a simple example that matches what it is I'm saying. You will all remember that the government moved a motion in respect of MH370, I believe, right? Now, MH370 is a case which involves different nations. You have suits filed in Australia, and there are, of course, other investigations in other parts of the world as well. So if we are going to look at it, right, in that perspective and a very narrow and restrictive approach, then I think we are going to have problems. It is not so much where the case is, it's a question of the substance. If the substance of it is fit and proper for discussion here in Malaysia, then it does not matter where the suit is filed. Motions can still be brought in Parliament, and the debate can still take place in Parliament Malaysia. And of course, in this case, needless to say, I think all of us can ask the most obvious question. Let's ask ourselves who Malaysian Officer 1 is, and then ask ourselves whether or not it relates to Malaysia. All right? I think that answers your question. Is that all right? Right. That's the second question. It works this way. I cannot go to court here and quote what Parliament has said. It doesn't work that way. We cannot just go to court and stand up and say to a judge, this is what so and so has said. There are rules of evidence that apply. So if I want to admit something, a debate in Parliament, for example, here, then there are rules that apply. And that's the reason behind that's the reason behind why it is the rule of sub judice does not apply overseas, to cases overseas. So if, for example, the trial in America, if they want to adduce evidence of what happens here in Malaysia, then they have to adduce evidence of the facts there. That doesn't so it does not involve Parliament at all. So if I say something here in Parliament, if I make certain allegations of fact, if those parties there are interested in having that evidence led, they will have to get the witnesses from here to go there and to lead that evidence. And of course, there'll be cross-examination and all that. So there's a process. There's a process.
So YB, you're trying to say if at all a minister answers a question here and they use it there, the minister would have to go there and be a witness there
if they're
on the dock and stuff.
That's number one. But the minister is always going to answer on facts. So in a court case, what will happen is they will require the facts. So calling the minister is not going to help them, because the minister is still going to base the answer on facts. So any lawyer would say that what we need to do is to get the facts. So we have to get the witnesses to make those facts available, after which those facts can be used in support of their case. So it's not as simple as that.
As an example, if the minister replies in Parliament here, the money came from donations, the DOJ is not going to summon the minister as a witness to say that the money came from donations. The DOJ will want the bank records on who the donor was, which account it went into, and the sum and the date and the bank involved. Those were the things that the DOJ would want, and not the minister who replied here.
There's evidence.
So, yeah.
Right. Can you?
They've already said that, I mean, Panika said that in his position as speaker, because he's like the judge,
of course he is.
He's already seen to it that PAC, which is bipartisan, has already made a decision, and therefore all that matters to his position is that PAC has made a decision, a committee has done its job. And he's also claimed that the only reason that you still want to debate the issue is simply because you want to keep one MPP matter alive.
I think
That's politics, right?
that's where the speaker has to decide on his role.
That's the speaker playing politics.
All right, hold on. Let me just address that from a more legal perspective.
I'll do the political.
Tan Sri Speaker, with great respect, is like all of us, bound by the standing orders. Now, if the standing orders allow debate, then I think, with great respect to him, it is his duty to allow the debate. Now, if he proposes to rely on a rule in order to restrict debate, then I think he must show us that he comes within that rule. So if he now raises sub judice as an issue, then we have to respond to that. Now, to say that he has allowed something to be discussed in the PAC does not mean that he can, on that score, reject debate of it in the Dewan. In any event, his decision on the 17th was not on that ground. Let us focus on his decision, because my review now is to attack that decision on Monday. And I have got the Hansard, and the Hansard very clearly says it's sub judice. So with great respect to the speaker, I think he should focus on what he said on Monday. And if he believes that it is sub judice, then perhaps he should mount an argument which convinces us that it is indeed sub judice. Going into the PAC and all that goes out of the subject of discussion. Yeah. Don't you want to add?
It is out of the subject of discussion because the focus of sub judice, and it is a terrible reason from the speaker. No, just because something has been discussed before doesn't make it such that it cannot be discussed again. That's number one. Number two, the speaker obviously did not read the PAC report, because the PAC report did not clear 1MDB. The PAC report also didn't touch on Najib. So if you want to deal with Najib, I'm quite happy for the PAC to do an investigation just on the Prime Minister.
The PAC talked about the DOJ was after.
No.
Yeah, so I think DOJ came later.
Yes.
After the PAC and after the last sitting. Right? So it's something new.
So the reasoning on the PAC having gone through the investigations, we never cleared 1MDB. The speaker said that, which means that he never read the report. Makes it all the more that the speaker is grasping at straws in order to cover up the case from being discussed in the parliament.
It will have no evidential effect.
No evidentiary.
I think our position is very, very clear. Can I go to court here in Kuala Lumpur and quote what happened in a judicial in the parliamentary proceedings, say, yeah, you know, in some other country? Yeah, but I am quoting now Erskine May to him, which says that that rule, yes, it can, but only applies to local decisions, local court cases. It does not extend to a country overseas. And I think I'll go into that in detail in the day one later, because we have the Evidence Act. The Evidence Act actually speaks about proceedings in Parliament. So that's the reason why, what do you call it, to be careful on what we say here. It cannot apply to a proceeding overseas.
So I mean, just to get it clear.
Sorry. The American lawyer can quote statements from here.
But they have to back it up.
That's right. In order for it to become admissible for its facts in the case there, then they have to lead evidence to that effect. Okay?
Okay.
So you
Come
mean
let's-
that they can actually use, I mean, they can quote it, but it will not be able to influence.
Yeah.
Of course not.
Unless they
There's no
produce
evidence
evidence.
unless you back it up.
Yes, I mean the speaker says he's a judge. He should understand that all judges, they have to go by evidence adduced in accordance with
hearsay.
law. Yeah, not hearsay and not quotations from books or excerpts without evidence to back those statements up. Before I end, I just need to ask all of you all to look at the statement. There are two corrections that I wish to make. First, on the first page, a spelling error. Dewan Rakyat, not Dewan Rayakat. I think my, okay, just
the
in
frustration
case.
behind that.
And I'm sorry, it's not paginated, but first page, second page, third page, fourth page, and on the fifth page, starting with the words Tuan Speaker. Do you have that? Can you look at the second paragraph, where I refer to Singapore, United Kingdom, and America? Do you have that?
Yeah.
Ada kan? So it's not United Kingdom. It's supposed to be Switzerland. Switzerland. So there's a typo error there.
Switzerland and US.
Singapore, Switzerland, and US. Okay, can you please make that correction? I'm sorry for those typo errors. Any other questions from members of the press? So I hope the speaker will give me my day in the day one. He made this decision on his own. I think he should hear us out and reconsider. I mean, he can, of course, fall back to his earlier decision. There's nothing to stop him. But at least hear us out and let us get this dealt with properly. I think this is a decision made by the Malaysian, the Speaker of Malaysian Parliament, which everyone all over the world will talk about. Because this issue is not an issue which is just local. It's an issue which has now caught the attention of the international world. So let's make sure that if such a bar is to be placed on members of parliament, let's make sure there's good reason for it and there's a debate that precedes it, so as to ensure that people recognize the fact that everybody was heard before that decision was made. All right?
Do you think the speaker's decision was politically motivated?
I do not know. You have to ask him that.
I'll say it.
Yes, please. Is it politically motivated?
Said it already,
Absolutely. I said it already. His decision is clearly politically motivated.
Yeah.
Would he claim otherwise?
God forbid. He said God forbid that he's not trying to defend someone or save someone.
God save him.
There's a saying, they say that he thinks so, I have no doubt. But that he's wrong, I'm sure.
Alright, thanks, Abi.
All right. Thank you.